Okay, we are now recording.
Okay. This hearing of the New Mexico Department of Health will now come to order. I would like to welcome you to the public hearing on the proposed amendments to 7.34.4.28 NMAC of the New Mexico's Department's Medical Cannabis Program rules. In particular, the department is proposing to amend 7.34.4.28 NMAC, the reciprocity rule, which includes amendments adopted on October 8th, 2020 via an emergency rule, and includes new requirements concerning what does and does not constitute, quote, proof of authorization, end quote, for purposes of reciprocal participation in the medical cannabis program, as well as revisions to registration, verification, and tracking requirements. In addition, the department is proposing amendments to other portions of 7.34.4.2 NMAC and other associated provisions, including but not limited to revisions to the reciprocal limit on the quantity of medical cannabis that a reciprocal participant can possess, and new material limiting the period of time in which a reciprocal participant can participate in the medical cannabis program. Pursuant to notice, this matter is being heard this fourth day of December 2020 via Cisco WebEx line and via telephone. Pursuant to notice, the public has been given the opportunity to comment on the proposed rule via Cisco WebEx and telephonically, and the opportunity was also given to the public to submit written comments via email messages through the close of business today. Actually, the notice said through the end of this hearing, but you will be allowed to provide written comments through the close of business at 5 o'clock this afternoon. The time is approximately 9:03 a.m. I am Craig Erickson, and I've been appointed by Acting Cabinet Secretary Billy Jimenez to preside over this hearing today. Assistant General Counsel Chris Woodward will be advising the department in this proceeding, and Dr. Dominic Zerlo, the Medical Cannabis Program Director, is also in participation in this hearing. This proceeding is being held in accordance with NMSA 9-7-6E of the Department of Health Act and the default procedural rule for rulemaking found at 1.24.25 NMAC. We'll proceed with the hearing in the following manner. Dr. Dominic Zerlo is going to give a brief introduction regarding the proposed rule amendments. Chris Woodward is going to provide some additional background on the rule. I will then ask him to identify the exhibits that have been provided to me in an exhibit binder and move for their admission. And then we'll take public comments from the public, from those of you who would like to offer public comments this morning. I'd like to remind those of you who do offer public comments today that this hearing is being recorded. So it's first, before you speak, if you could identify yourself and whether you're appearing on your own behalf or representing some organization, and then be sure to speak loudly and clearly so that we get a good recording of the proceeding today. Further, I'd like to just let you know that the department is not bound by the formal rules of evidence during this proceeding. However, I may, in my discretion, exclude evidence that is incompetent, irrelevant, immaterial, or unduly repetitious. And with that, I think we can go to Dr. Zerlo's introductory remarks.
Thank you, Mr. Erickson. I appreciate you being here and presiding over this rule hearing. And so at this point in time, what I would like to do is provide a summary of the Medical Cannabis Program Rule Amendment for 7.34.4.28. The purpose of the proposed amendments is to revise requirements for participation as a reciprocal participant in the New Mexico Medical Cannabis Program. And this falls under several different portions. The first portion is 7.34.4.28, reciprocity, to amend the first sentence by stating a qualified patient may not be registered or participate as a reciprocal participant in the New Mexico Medical Cannabis Program. The reasoning behind this amendment is to ensure that individuals who are otherwise enrolled or may be enrolled as qualified patients in the New Mexico Medical Cannabis Program do not become registered or attempt to participate in the program as reciprocal participants. In essence, that they would not be allowed to double dip and enroll both as a qualified patient and as a reciprocal participant. Section A3A of that same portion, the residency requirements would be amended to require that a person who is not a resident of New Mexico may participate in the medical cannabis program as a reciprocal participant, provided that the reciprocal participant's place of residence is consistent with their place of enrollment. This is to ensure and to address a concerning trend where persons who have been allowed to participate reciprocally in the program are actually reside in the same state as their enrollment in another program, another medical cannabis program. The department had found that it is not the intention and was not the intention of the New Mexico legislature to permit an individual to participate in the New Mexico medical cannabis program as a reciprocal participant on the basis of an authorization issued by a jurisdiction other than the person's place of residence. That the purpose of reciprocity was to enable a person who travels to New Mexico from their home state is able to obtain medicine during their visit based upon the authorization of their home state. And with this in mind, the department has proposed to amend the rules consistent with that legislative purpose. New Mexico, Section A3B, New Mexico residents. This amendment would require that a New Mexico resident who is not a member of a New Mexico Indian Nation, tribe, or pueblo shall not participate in the medical cannabis program as a reciprocal participant, but may pursue enrollment as a qualified patient in accordance with Rule 7.34.3 and MAC. This amendment is also being proposed to address another related trend in which New Mexico residents have utilized authorizations to participate in medical cannabis programs of other states to participate reciprocally in New Mexico. This, in effect, bypasses the current enrollment requirements that would otherwise apply to those New Mexico residents. The department finds that reciprocity was not created in the statute to enable New Mexico residents to circumvent the current enrollment criteria of the Lynn and Aaron Compassionate Use Act. And this amendment is a way to go ahead and ensure that that does not happen in the future. Section B, reciprocal limit. This amendment would modify the reciprocal limit from 230 units for 3 months to 230 units for 1 year. The amendment is proposed in recognition of the fact that reciprocity, as explained, was intended to allow persons from other jurisdictions to visit New Mexico and participate temporarily in the New Mexico medical cannabis program while visiting the state. The Lynn and Aaron Compassionate Use Act expressly authorizes the department to identify requirements for the granting of reciprocity, including provisions limiting the period of time in which a reciprocal participant may participate in the medical cannabis program. The department has proposed to limit the amount of cannabis a reciprocal participant can obtain without decreasing the time period in which a participant can participate reciprocally. This will help to ensure supplies of medical cannabis are reserved to qualified patients who are enrolled in the program, as well as providing medication for those reciprocal participants who are also obtaining medication through the program during their visit to New Mexico. Section C, registration, verification, and tracking. Part 2, this amendment would require the licensed nonprofit producers to compare a person's proof of authorization to participate in the medical cannabis program of another jurisdiction with their government-issued photo identification card and verify the information, including but not limiting to the place of residence, is consistent. Section C4 of the amendment would require a licensed nonprofit producer shall not register an employee or board member of the producer as a reciprocal participant. This amendment is intended to avoid conflicts of interest for licensed nonprofit producers in registering reciprocal participants. C5, the amendment would require that at the time of registration, a licensed nonprofit producer shall electronically upload a copy of the reciprocal participant's proof of authorization and a copy of the reciprocal participant's government-issued photo identification, which indicates and includes the person's place of residence, into the electronic tracking system specified by the department. The reason for this amendment is to ensure that the appropriate documentation concerning a reciprocal participant is indeed being checked and is kept on file. C6. Amendment would require a licensed nonprofit producer shall ensure the individual registering as a reciprocal participant is not already registered as a reciprocal participant or a qualified patient in the New Mexico Medical Cannabis Program before entering registration information for the individual. This amendment would further provide that repeated registration of a reciprocal participant who was previously registered may result in disciplinary action in accordance with this rule. This amendment and these amendments are intended to ensure reciprocal participants are not registered multiple times or permitted to purchase medication and medical cannabis under duplicate registrations. Section C6. Amendment would require that licensed nonprofit producers ensure, when registering a reciprocal participant, that the reciprocal participant signs their registration in the electronic tracking system, acknowledging that the individual understands participation requirements in the program. This would also expressly prohibit producers from substituting any signature for that of the reciprocal participant, subject to disciplinary actions. These provisions are intended to ensure that reciprocal participants acknowledge their understanding of program requirements and to ensure that the reciprocal participants' acknowledgement is appropriately documented. Section D, proof of authorization. The amendment would specify that proof of authorization to participate in the medical cannabis program of another jurisdiction, an originating jurisdiction, shall consist of a card or other physical document issued by a governmental entity authorized by law to enroll the applicant in the medical cannabis program in the originating jurisdiction. This passage would also specify that permission from a medical practitioner shall not in itself be deemed proof of authorization to participate in the medical cannabis program of another jurisdiction. The department finds that a letter from a medical practitioner taken alone is not sufficient to demonstrably prove that an individual has been authorized to participate in the medical cannabis program of another jurisdiction. A letter that is issued by a medical practitioner can easily be falsified, and a letter taken alone does not offer or afford the same degree of proof as a card or other legal document that is issued by the originating jurisdiction to authorize participation in that jurisdiction's medical cannabis program. A letter from a medical practitioner taken alone also does not provide any verification that the practitioner who signed the letter is in good standing with their licensing body, whereas a card or other authorization issued from a governmental entity in the originating state or jurisdiction provides greater assurance that the reciprocal participant has indeed met the eligibility requirements of the originating jurisdiction. Accordingly, the department interprets the expression proof of authorization as it is used at NMSA 178, Chapter 26-2B-7 as a card or other physical document issued by a governmental entity authorized by law to enroll the applicant in the medical cannabis program in the originating jurisdiction. The department proposes to modify the rule to reflect this understanding, this consistency with the agency's statutory authority to establish requirements for the granting of reciprocity. In addition, I would like to add that these proposed amendments and summaries have also been referred to the Medical Cannabis Medical Advisory Board for their consideration. Thank you.
Mr. Erickson, you are muted right now. If you can unmute yourself. I apologize for that, Mr. Erickson. I temporarily muted you. I noticed that we were getting some feedback from your microphone when Dr. Zerlo was speaking. And it looks like, although I can mute you, I cannot unmute you. So I do apologize.
Okay. Yeah, no, I just noticed that, and thanks for doing that. I noticed the feedback as well at the beginning of Dr. Zerlo's remarks. So we should continue. You can continue muting me, and I'll try to remember to unmute myself. And what I was saying was that at this point, we'll move to you, Mr. Woodward, for the introductory remarks that you would like to make.
Oops. Can you hear me?
Yes.
Okay. Yes, just as a few introductory matters.
So if you'd like, you should mute me again.
Oh, okay. I'll do that.
Okay.
Okay, you are now muted. Just as a few introductory comments regarding this rule. An earlier version of this rule was adopted as an emergency rule in early October. I believe that was October 8th. An emergency rule was adopted by the acting cabinet secretary, Billy Jimenez. And there was some subsequent litigation regarding that emergency rule that is ongoing in the Santa Fe District Court. That is in case number D-101-CV-2020-2059. That is a case before Judge Wilson in the Santa Fe District Court. A writ of mandamus was issued in that case on October 13th of this year, so shortly after the emergency rule was adopted, and it had the effect of invalidating the emergency rule on the stated basis that it did not satisfy the imminent peril requirement of the emergency rule requirements in the State Rules Act. Now, there is a pending motion in order to show cause. In that case, there's a contest between the parties regarding the meaning and effect of the writ of mandamus, and that order to show cause is scheduled for a hearing next week. I believe that's Thursday of next week, and so this particular proposed rule is being pursued pursuant to the State Rules Act, and it is the Department of Health's position that it is permitted within the terms of the court's writ of mandamus to continue pursuing an ordinary rule following the ordinary rule making requirements of the State Rules Act rather than emergency rules. But as I say, there is a hearing scheduled for next week. We anticipate that there will be a decision next week from the district court judge, and we will certainly be apprising the hearing officer of whatever result comes out of that. Obviously, it is possible that the result of that hearing could have an impact on whether the agency is able, as a matter of law, to adopt some or all of the proposed rule in this case. And so that is my preface on that. And with that, if the hearing officer will permit me, I would like to introduce the department's proposed exhibits in this hearing.
Yes, you can go ahead and identify the exhibits in the exhibit finder for their admission.
So the department has offered a total of 10 exhibits. One of these is a placeholder for public comment. I believe as of the close of business yesterday, I don't believe we had received any written public comment, but I understand that some has come in this morning, and we will be forwarding that on to the hearing officer today. As the hearing officer stated earlier, for everyone who's attending today, the deadline for the submittal of written comments has been extended until 5 p.m. today. So if anyone would like to submit written comment, you can submit that to the address listed in the public hearing notice. So we have a total of 10 exhibits at this point. I understand these have been posted on the Department of Health website on the regulations webpage. So I think probably the easiest way to go there if you're interested is to go into Google and do a web search for New Mexico Department of Health regulations. And it's either the first or the second option that pops up in the Google web search, the regulations webpage of the department. And FYI, we found that particular web page, sometimes we've experienced some delays in the loading of that web page. If you encounter issues with that, I recommend loading the Microsoft Edge browser. That seems, for whatever reason, that seems to be more effective at loading that page. So if you run into any issues, but as I said, the exhibits are posted on that website, or at least I'm told that they are posted there. So without further ado, the exhibits that we are offering today, exhibit number 1 consists of the actual proposed amendments to section 7.34.4.28 NMAC, which Dr. Zerlo described a moment ago. Exhibit number 2 is a summary of the medical cannabis program rule amendments to this section that includes much of the material that Dr. Zerlo was describing, basically a summary of what is proposed to be changed in the rule section and the rationales behind it. So that is our proposed Exhibit 2. Exhibit 3 is the notice of public hearing. Exhibit 4 is an affidavit completed by Sheila Apodaca concerning the actions that the agency has taken to provide public notice of the rule hearing and rulemaking in accordance with the State Rules Act. Exhibit 5 is an affidavit of publication in the Albuquerque Journal, also done in accordance with the State Rules Act. Exhibit 6 is an affidavit of publication in the New Mexico Register. That is, of course, also a requirement to publish it in the Register in advance of the hearing. Exhibit 7 is the letter appointing the hearing officer, Craig Erickson. Exhibit 8 consists of a comment received. And I apologize, I always struggle trying to remember the exact name of this advisory board, but Exhibit 8 is a comment received from Johanna Nelson, who is with the SBRAC, and I want to say that stands for the Small Business. It's a Small Business Advisory Commission, and so basically the department forwarded a copy of the proposed rule to this commission in accordance with statute, asking if they had any comment regarding this, anticipating that it could have potentially an impact on small business, which is sort of the purview of this advisory body. And Ms. Nelson, who is a representative of theirs, wrote back stating that the SBRAC reported no adverse findings related to the proposed rule. So that email exchange is contained at the department's Exhibit 8. Exhibit 9 is sort of a placeholder at this point for the public comment, the written public comment received and to be received by 5 p.m. today. As I say, I understand that we have received some written public comment, and we will be getting that to the hearing officer today. And finally, Exhibit 10 consists of a meeting agenda of the Medical Cannabis Advisory Board, which met on November 16th. And one of the items on their agenda was to review the proposed rule changes that we're discussing today. I understand that the Medical Cannabis Advisory Board did not render a final recommendation regarding the proposed rules. However, they will be taking this up. They essentially tabled this item, and they'll be taking it up again at their meeting that is scheduled for next week. And I'm forgetting exactly what day that. I want to say it maybe Tuesday or Wednesday. So we do anticipate, and on this point, we do anticipate that we will have a recommendation from the Medical Cannabis Advisory Board next week. And once we have that information, we will be passing that along. And so I would just ask that the hearing officer leave the comment period open past the 5 p.m. deadline today, just especially for that particular piece of information, whether it be in the form of meeting minutes or a communication from the medical cannabis program regarding the outcome, because of course we want to get the advisory board's recommendation to the hearing officer and have that considered among the comments. And so with that, I would move the admission of exhibits 1 through 10 into the record of this rule hearing.
And the exhibits will be admitted, and I should indicate that I have received one written comment from Alter Health just this morning. So I have received the first, I don't know if there are more written comments that have come in this morning, but I have received that particular one. And with that, I think we can proceed with opening up the hearing for public comment. And I just want to remind you to identify yourself and indicate whether or not you're appearing on your own behalf or on behalf of some organization. And Ms. Sundberg is going to facilitate each of you having the opportunity to offer public comment if you would choose to.
Thank you, Mr. Erickson. Good morning, everybody. If you are interested in providing public comment, go to the participants section in the lower right-hand corner of your screen, and you click on it, find your name, and raise your hand. We will call on you to provide that public comment. And Mr. Erickson, if you could just remind me what the time limit is on the public comments. Oh, you're muted.
Yes, it'll be 15 minutes.
And Mr. Erickson and Ms. Sundberg, just as a reminder for you, Ms. Sundberg, I note that we do have some participants in the hearing today who are calling in via telephone, and so those individuals will not have the ability to click on a screen. And so I would just ask that for those individuals who are participating by phone, that you call on them individually based on the number that displays on the screen, so that they are queued and they have a fair opportunity to speak.
Thank you, Mr. Woodward. I will make sure to do that.
Thank you.
Thank you. Okay, our first participant is going to be Jacob Candelaria. Mr. Candelaria, you are unmuted.
Thank you, Ms. Sundberg and Mr. Hearing Officer. Thank you for the opportunity to make public comment today. I am Jacob Candelaria of Candelaria Law, LLC. Also with me today is my legal associate, Fernando Guillen, and we represent New Mexico Top Organics Ultra Health, Inc. As you referenced, Mr. Hearing Officer, my clients submitted extensive written exhibits proposed rule. I really encourage hearing officer to pay attention and to review it this of mandamus that has already been entered in this case.
Mr. Candelaria, if I could interrupt you for a moment. When you began your presentation, you were coming through loud and clear, and you indicated that you had somebody in your office with you, and I presume you're on a speakerphone. Unfortunately, what happens often with this platform, if somebody's on a speakerphone, their discussion becomes broken up, and that's started happening already. And I want to have a good record of what you have to say. So I'd like to ask you to not be on the speakerphone if that's the case.
I'm not on a speakerphone.
Okay. Are you recording? Did you hear my question, Mr. Candelaria?
All the department members have their video on. It's taking a lot of data, and if the may turn, maybe that would help bandwidth issues.
Unfortunately, all of that was completely broken up. I think you were saying that you thought somebody had their video on.
Yes, I'm saying, Mr. Hearing Officer, since all the department has their video on, it's taking a lot of data, which makes the connection very unstable for participants.
Oh, okay.
So if we could just, maybe if people can turn their video off during public comment, that'll avoid as much interruption in the feed.
Yes, that would be great. So,
Thank you,
okay.
Mr. Hearing Officer.
I see that Mr. Woodward has removed his video. Ms. Sundberg, can you do that as well? Well, thank you. We're all learning about this platform, and I appreciate that new insight, Mr. Candelaria, into multiple people being on video. So it's not a perfect process, but we're
No
getting
worries.
better.
So,
All right, why don't you start over now?
Perfect. And Mr. Hearing Officer, again, my name is Jacob Candelaria. I am the lawyer for New Mexico Top Organics Ultra Health Inc. Also with me in my office today is my associate, Fernando Guillen, and we are appearing on behalf of Ultra Health this morning. I'm going to direct the hearing officer's attention, if I may, to the written submissions my client provided yesterday afternoon, and in particular to the writ of mandamus that the district court has already entered into this case. It was represented by the department, Mr. Hearing Officer, that the scope or the effect of that mandamus order was limited to simply a consideration of whether or not the October the 8th emergency rule met the imminent peril standard for issuance of an emergency rule under the New Mexico Rules Act. As you can see in Judge Wilson's order, that is not the full holding of the district court. In the court's mandamus order, the district court, and I'll refer you to page 3, Mr. Hearing Officer, of my client's written comments, the district court specifically holds that the language of the department's 9/11 mandate, the language of the department's 10/8 emergency rule, and the language that the department has now copy and pasted into its October 27th rule notice regarding amendments to 0.4.28A3 regarding residency requirements, and the department's amendments to 7.34.28D regarding proof of authorization. The district court has already held that these changes are unlawful, that these proposed changes to the New Mexico Cannabis Act and to the reciprocity section exceed the department's authority and are contrary to the Medical Cannabis Act. The department today, again, has offered evidence of various policy reasons why it, as an agency, thinks that it should be allowed, or that the rules it wishes to adopt are better policy than what the legislature has put in place. But as the district court held, the legislative intent is very clear. When the legislature established the reciprocal medical cannabis program, they did not define a reciprocal patient with respect to residency. The district court has already found, regarding this specific language, that the legislature did not intend to prevent New Mexico residents from enrolling as reciprocal patients. The district court found, and my client argued before the court at that time, that it's equally possible that the legislature created a new avenue whereby New Mexico residents and non-New Mexico residents could become medical cannabis patients. And let's not lose sight, Mr. Hearing Officer, of what we're actually talking about here. We are talking about access to medicine. These are medically frail people. The department enrolled thousands of these types of people between June and September of 2020, prior to initiating this attempt to restrict access to the reciprocal cannabis program in a way the district court has already said violates legislative intent. So Mr. Hearing Officer, the next issue then becomes, as an officer of the court, I have a lot of concern about this hearing even being conducted today. Judge Wilson granted my client's motion for a show cause order. The department has been ordered to produce a response and to appear at a hearing on December the 10th of 2020 to determine whether or not the department's publication of these rules changes to, I'm just going to refer to it as to the proof of authorization section and to the residency section, already constitutes a violation of the court's order and already puts the department in contempt of the court's mandamus order. Because I will point out, Mr. Hearing Officer, the court was very specific and prospective in the relief it granted. It said that the department must run the reciprocal program in compliance with the Medical Cannabis Act. And number two, it said that it must immediately re-enroll all the persons that the department had as of the date of the court's mandamus order kicked out of the program because, number one, they were New Mexico residents who enrolled as reciprocal patients, nor number two, the residency of their government-issued ID did or did not match the proof of authorization, and number three, the department's insistence that the Medical Cannabis Act allows them to require a medical cannabis card or some other government-issued form of ID as a proof of authorization. All of those questions have already been asked and answered by the district court. And so as an officer of the court, I think the appropriate thing for this hearing, Mr. Hearing Officer, with all due respect, is that it be suspended and that it be reconvened after the district court has actually heard and ruled on whether or not the department is already in contempt. My client also filed several days ago a verified application for temporary restraining order to prevent this hearing from happening. Interestingly enough, the judge did not deny that application for relief, but has held it in abeyance. And so I think that the fact that we have injunctive orders of the district court being held in abeyance until December the 10th, from basic principles of compliance with court orders, I believe the fact that the department has proceeded with this hearing, it needs to be noted for the record, constitutes further violation of the district court's mandamus order in this case. I want to address now, Mr. Hearing Officer, the other proposed rule changes before you that were not subject to the original mandamus litigation and that were otherwise not incorporated in prior versions of the department's proposed amendments to these rules. As I mentioned earlier, we've seen this language before on 9/11 and in the 10/8 emergency rule. The new material the department seeks is both a time limit and a quantity limit for reciprocal patients. Again, Mr. Hearing Officer, as a new matter, I would argue that both of those proposed rules are both arbitrary and capricious and far exceed the department's authority in violation of the Lynn and Aaron Compassionate Use Act. Nowhere in the reciprocal section of the statute did the legislature contemplate that reciprocal patients would be offered less access to medicine than a qualified patient. The department's attempt to create an unequal system that denies certain classes of patients, certain medically frail people, the medicine they need to get through the day simply because they are a reciprocal patient versus a qualified patient is not only not supported by the Medical Cannabis Act, I believe and would submit to this tribunal of one, that constitutes perhaps a violation of equal protection. Furthermore, we just reviewed all the exhibits, Mr. Hearing Officer, that were provided to you, and I will note none of those exhibits in any way provide evidence that substantiates that this this restriction to 230 units per year for reciprocal patients is in any way based upon science, is in any way based upon data. It seems to be what it is, an arbitrary selection to try and discourage and try and reduce and to try and create additional barriers that are unlawful for people to become reciprocal patients. The issue that the department, the last issue I want to raise, Mr. Hearing Officer, the department stated that its interest in reducing the amount of medicine that a reciprocal patient can purchase is because the department is concerned about quantity and assuring a supply for qualified patients. I would submit to you, Mr. Hearing Officer, that that is a red herring argument. I would submit to you, Mr. Hearing Officer, that in fact, the reason that New Mexico, and I think it's good that finally on the record, the Department of Health is recognizing that there is not an adequate supply of medical cannabis in the state. We've all known that. Everyone knows that, apparently, except the department. But it's good that they've admitted that, Mr. Hearing Officer, because let's look at why there are supply issues in this marketplace. There are supply issues in this marketplace because the department continues to impose a non-statutorily mandated, arbitrary and capricious plant count that limits the number of plants that any licensed cannabis producer can grow in New Mexico. If the department is truly concerned about ensuring adequate supply, they simply need to remove and to stop placing those arbitrary barriers to growing the amount of medicine in New Mexico that needs to be grown to meet the need of patients. That's what we're talking about here. New Mexico also has the highest price per gram for medical cannabis than our surrounding states. Why? Because of the department's artificial limit on the number of plants that licensed cannabis producers can grow. And so, Mr. Hearing Officer, with respect to the new material, to the cap on time of 1 year and to the cap of 230 units, those changes, while not at issue in the original mandamus order, are both arbitrary and capricious, and for the reasons I have stated, fall beyond the department's scope and are thus unlawful. But I return, Mr. Hearing Officer, to just complete my comments by really coming back to the really unique and to the really sort of concerning procedural posture we find ourselves in. The Department of Health already has a ruling before it from a district court judge saying that the language and the amendments they're trying to do to the residential requirements at 4.28A3 and the changes they are trying to do to the proof of authorization requirements at 428D are unlawful. There is no equivocation. There is no cracks in that interpretation. Judge Wilson's order is very, very clear. And so for that reason, I will end again with simply noting for the record, because I do believe if these rules, at least A3 and D, are adopted again by the department, that there will be additional litigation before Judge Wilson. I think it does need to be noted for the record that I, as counsel for Ultra Health and as a member of the bar, respectfully request of the hearing officer that in deference to the district court's orders, that you suspend this hearing and that it not be reconvened until such time as the district court has rendered its decision on the pending show cause order for sanctions against the department, as well as the verified petition for temporary injunction, which again currently sits before Judge Wilson in abeyance. We will have both of those hearings, Mr. Hearing Officer, on December the 10th, first thing in the morning. I do not think it would cause material prejudice to the department to simply wait less than 10 days in order to at least demonstrate good faith compliance with a standing lawful order of a district court judge. Thank you, Mr. Hearing Officer.
Thank you, Mr. Candelaria.
Thank you, Mr. Candelaria. And with respect to your request for suspension, I want to hear from all the other participants before I respond to that. And now we can go to whoever is next, Ms. Sundberg.
Thank you, Mr. Erickson. We're now going to ask for somebody that is on the phone if they would wish to make public comments. The last two digits of the phone number are 64. I will unmute you now. If you choose to make public comment, please let us know. Okay, hearing no response, we will move on to the next person. For a person on the phone, again, we will unmute your phone now. Your last two digits are 00. If you would like to make a public comment. You can also, for those on the phone, you can also press, I believe it's *3 to raise your hand.
Hi, this is Duke Rodriguez with Ultra Health. Andrea, can you hear me?
Yes, I can hear you, Duke. Thank you very much.
I'm 00.
Thank you.
Thank you for the opportunity to comment. I'll keep my comments relatively short. If you can't hear me, I'll speak up. Otherwise, I will assume the connection is clear. I want to start by saying I'm completely bewildered by the agency's desire to be callous and uncaring about the needs of medical cannabis patients. The purpose of the Lynn and Aaron Compassionate Use Act is clearly spelled out in the law to allow the beneficial use of medical cannabis. It is not about denying, restricting, or limiting participation. It is simple and clear to allow the beneficial use of medical cannabis without exception or debate. And not to be redundant, but to be clear, it is to allow for the beneficial use of medical cannabis. We should all be putting emphasis on the word allow. The current pandemic is the single biggest health event in the last 100 years. New Mexico is breaking record after record of new COVID-19 cases, and even more sadly, with a record number of deaths. Those we have lost, we cannot recover, nor should we forget. And as for those of us who remain, and I am talking about both groups, those who've already been infected and those who have not been, there is left a painful trail of depression, anxiety, stress, anger, fear, isolation, suicide, insomnia, increased use of alcohol and illicit drugs, and overall, an increase in general suffering and a substantial decrease in well-being. I personally have received more than one personal note from a patient saying the single ability to access cannabis through the reciprocal participant program saved my marriage. One patient specifically said, "You saved my life." As you all are well aware, New Mexico is last on so many lists. Will we be last in realizing that this is a medicine like any other prescription? A medicine that is in need today and a need that will exponentially increase going forward. Cannabis is a meaningful medicine that actually changes and saves lives. Instead of continuing to put up barriers to access, we should be opening up our hearts and minds to the clear fact that we need more, not less, of available cannabis care, which means broader, more compassionate reciprocity requirements. Remember, these barriers that the DOH keeps proposing are born not in the heart of compassion, but in the thoughts and minds of racism and discrimination. There are now more than 5,000 reciprocal participants in the program. DOH has failed to evaluate how devastating these new requirements would be for thousands of individuals. No official reports, no memos, no examination of how these regulations would strip access to medicine. DOH is acting, Mr. Hearing Officer, with reckless disregard concerning access to medicine for thousands of people. The department first promulgated regulations that did reflect the Linen, Air, and Compassionate Use Act. The agency cannot strip these regulations and jeopardize the well-being of thousands of individuals during the biggest healthcare event in the last 100 years, all because they simply did not like the outcome of the regulations that reflect the statute. For once, I ask you, please set aside your absurd rulemaking on reciprocal participants and simply carry out the statute as written. If you are not happy with the statute, then go talk to the legislature. Otherwise, simply follow the law and, quote, allow the beneficial use of medical cannabis. Thank you very much.
Thank you, Mr. Rodriguez. Ms. Sundberg, you may proceed.
Thank you, Mr. Erickson. Thank you, Mr. Rodriguez. I do not see anybody else's hand raised at this time. If somebody, oh wait, hold on one second. I'm sorry. Yeah, I'm sorry. I do not see. Let me double check here real quick. Okay, the person whose phone number is ending in 64 does have their hand raised for public comment. Give me 1 second to get you unmuted. Okay, for some reason your line is not unmuting. Let me continue. I'll check down the list and I will come back to that. Ms. Jensen, if you could try unmuting it, or Chris, if you could try unmuting the phone number 64 to see if that works.
Yes, I am also trying to unmute the number. Oh, it looks like 64 is now unmuted.
Okay, yes, it is. Thank you.
This
Person with phone number ending in 64, you're now unmuted.
Can you all hear me?
Yes, we can. Please remember to state your name for the record as well. Thank you.
This is Kylie Safa. I'm with Ultra Health. I submitted written comments yesterday afternoon, and I believe I got confirmation this morning that they were received.
Ma'am, if I could interrupt, ma'am, could you state your name again? I may ask you to stay as well. I couldn't hear your name at all.
My name is Kylie Safa, K-Y-L-I-E. Last name is S-A-F-A.
Thank you, Ms. Safa. And are you appearing on your own behalf or on behalf of an organization?
I'm with Ultra Health.
Thank you. You may proceed.
Thank you. So as I was saying, I submitted written comments yesterday afternoon, and I received confirmation this morning that they were received. So you should have those for your record, Mr. Hearing Officer.
Yes, I've received them already.
Okay, great. Then as you know, they're quite lengthy with the exhibits, so I won't go over everything that's in there. I just wanted to add some additional comments verbally for the record. Aside from the points that have already been made this morning about the proposed amendments being unlawful and contrary to the statute, there's also no rationale presented by the department for why the newly proposed purchase amount of 230 units for the year is reasonable or is not arbitrary and capricious. Part of the policy position of the department stated by Dr. Zerlo was that the reduced purchase limit would ensure more sufficient supply for the patients enrolled in the program for the New Mexico qualified patients. And I think it's pretty clear that the solution to the supply issue acknowledged by the department today is to increase the production limits so that licensed cannabis producers can ensure an adequate supply, and so that patients are not further restricted from accessing that medicine. The solution is not to restrict patient access. The solution is to increase the supply so that patients can have the access that they are granted by the law. Additionally, I wanted to acknowledge that there are many populations that aren't being considered in this rule. For example, students who come to the University of New Mexico or New Mexico State. There are many students who come from out of state and they don't change their residency. That's very common for those in the university, and restricting their access to 230 units within a year would be unreasonable, considering they spend at least 9 months in the state during the term. Another group that's not being considered are the snowbirds, people who spend a seasonal time in the state, whether they come during the winter from the colder parts of the country, or if they come for the summer or the fall to see the balloon fiesta. There's a lot of people who have a second home in New Mexico, and they spend a disproportionate amount of their time in the state, but are not technically residents of the state. So those people would also be restricted from accessing medical cannabis as is allowed by the statute. And to reiterate a point that was made previously, the purpose of the act is to allow the beneficial use of medical cannabis. It's not to restrict access. It's not to prevent people from accessing the beneficial use of cannabis. It's to allow the beneficial use of cannabis. And what this rule does is clearly the opposite. People need to access their medicine, and it should be noted that in the last medical advisory board hearing, the advisory board did recommend that the Department of Health actually increase the purchase limit for qualified patients. So I think even that is proof that the current limit at 230 units for a 90-day period is unreasonable, and then to restrict it even further for reciprocal participants to 230 units in a year is simply absurd. I believe with everything else that was mentioned today and those few comments there and what you have in writing, that it's very clear that these rules should not be promulgated as written. Thank you.
Thank you, Ms. Safa. Ms. Sundberg? You're still muted. Ms. Sundberg, you're still muted.
Mr. Erickson, Ms. Sundberg had a technical issue and had dropped off the call and is just now rejoining, so it may take a moment for her microphone to be functional. Actually, I believe it is now. Ms. Sundberg, are you back?
I can see her on the screen, but there's no indication of whether she's muted or unmuted.
Right. With that being the case, are there other individuals who wished to provide public comment? At this point in time, the only other individuals who have not been asked are Ms. Caffrey and Ms. Novell. If you would like to speak, if you could please raise your hands. Thank you, Ms. Novell. I appreciate the message in the chat window that you have no public comments. And also thank you, Ms. Caffrey, as well. I do believe that is everybody who is on the call who are members of the public with regard to this. If I have missed anyone, if you could please go ahead and send a message in the chat or raise your hand. Okay, I do not see any additional requests, Mr. Erickson, so I will turn this back over to you.
Okay, thank you, Dr. Zerlo. So with respect to the request by Council for Ultra Health that I suspend the hearing, obviously I did not suspend the hearing as to the opportunity for people to offer public comment today. I understand that there are proceedings happening in district court and Judge Wilson's court next week. I'm not going to be issuing a recommendation on this matter until we know more about what happens as a result of those hearings next week. And so in that sense, I am suspending making a recommendation until after we learn more from the court next week. I'd like to thank all of you for participating in the hearing today. Let me just check with Mr. Woodward and see if there's anything else that he thinks needs to be addressed before we close the proceeding.
No, Mr. Hearing Officer, I have nothing further.
Okay, well, we can go off the record, and thank you again for your participation.
Thank you.
Thank you, Mr. Erickson.